Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nonni.
And I'm Jaeson Homola.
And this is
It's No Accident. All right, I've got a case right now that's brought up some issues that we thought would be good to talk about on this podcast. And it has to do with what minors' rights are as far as when they're injured in a car wreck or they're injured in any sort of case where they have an injury and there's negligence involved. And it comes up a lot because, anybody 18 and under, they don't have the right to contract with an attorney. They don't have the rights to make decisions about settlements. So parents all the time in these situations are asking, what's the process? What do we have to do? Does the court have to get involved? Do we have to have an attorney ad litem involved, guardian ad litem involved? Where does the money go after the fact? So do you want to talk a little bit about, just getting the case going and, what rights the parents have, what rights the minors have, and, what we do in a situation where there's a minor that's injured?
Yeah, no, for sure. I mean, definitely, like you said, comes up a lot, whether it's, a minor being in a car and getting in a car wreck or, getting hurt at a store or something like that. It, comes up pretty frequently. And, I'd say in a lot of ways, like, for example, a car wreck case where the person gets injured in a car wreck, in a lot of ways, the way it works is the same for an adult and a minor, but there are some really big differences. Like one you said is, the minor can't hire an attorney. The minor can't, if you're under 18, you can't enter into a contract, right? And so the parent, or whoever the guardian is, whether it's a parent or, sometimes you have situations where maybe, the parents aren't in the picture, and so the grandparent's the one who's in charge of the kid. Whoever's in charge of that kid, has the right to basically hire an attorney on behalf of the kid. And so, like, if it's a mom and a kid and that are in the car wreck together, a lot of times what we'll see is the mom will hire us to represent her personally, and then also hire us to represent the child as well, right? And so that's one big difference. Then also with just this decision making, like you said, when it comes to deciding if you're going to settle or not, you're not going to ask the 7-year-old, right? So you're talking to the parent about it, and the parent's making the decision. But I'd say really the big thing that people don't realize, and sometimes it's kind of surprising to them, is at the end of the case, assuming you get a settlement or some type of recovery, potentially there's going to be a situation where you have to get court approval before you can actually settle. And then beyond that, there's also a situation where, assuming the court approves it, a guardianship has to get set up to basically be in charge of the money for the kid.
Sure.
Right? And the court approval, I think it's if the gross settlement is $15,000 or more, I think is what the cutoff is. If the total settlement is $15,000 or more, then you got to get court approval before you can actually settle, right?
It's a fairly low number. I think you're right. I think it's 15,000, and it doesn't take much for that to happen. And
especially these days with some of the medical bills you see coming out of ERs.
Yeah, and so what happens in a case with a minor is pretty much every case with a minor, or the large majority of cases with a minor, they end up with needing to get court approval. And a lot of times the court is going to defer to what the wishes of the guardian, the wishes of the attorney. But also one of the other things that you have to do, and this comes up in cases where it's not every single case where it's gross settlement of $15,000. It actually, I think it's $25,000 or $50,000. You get to the point where an attorney ad litem or a guardian ad litem, some sort of outside observer, has to get involved. They get appointed by the court. You send all of the settlement information to this attorney ad litem or guardian ad litem. They look through all of the information. They talk to the attorney. They get a good understanding as to what the facts are, what the injuries are, what the treatment is that the minor might need in the future. And then they send a report to the court either saying, I've looked over everything and I think it's in the best interest of the child to move forward with the settlement. This is a good settlement. Or I've looked over everything and actually, you know what, I think they probably could have done better. It looks like there's more insurance money that's available out here that they haven't looked into, or there's some issue with the settlement, and they'll write a report that says, I can't sign off on this until such and such has happened. So really what it's doing is it's bringing in an independent third party to look over everything to give their opinion as to what should be done in the case.
Right, right. And the big picture being really just to protect kids, make sure the kids don't get screwed over, right? Whether it's by their own, you wouldn't think that parents would screw their kids over, but, it happens sometimes. I'm sure you would agree, like the times when I have these conversations with clients and I'm explaining to them, now we're about to have to jump through these hoops, a lot of times they're kind of like annoyed or pissed, like, well, why, is the law insinuating I'm going to screw my kid over? And it's like, well, no, like, no, you're a great person, a great parent. No one, I don't think that you're going to do that, but the laws aren't written for the good people. They're written to protect kids from the bad people who are going to try to do something shady, right?
Exactly. And I'll say by and large, most of the parents that you talk to and well, you'll tell them at the forefront, you'll be like, we've settled the case, but look, this might take another 2 or 3 months to get this thing approved by the court. At first, they're frustrated. They're like, man, this stinks. Why do we have to do this? But when you explain to them why we're doing what we're doing, by and large, the parents are going to say, well, I get it. I understand. It's actually good that they have these safeguards in place. And even after the case is over, after the court approves the settlement, where does the money go?
Right.
What happens to the money that the minor gets? Does the money just go to the parent? The parent is left to make decisions on what happens with the money, or does it go into a bank account? Like what happens at that point?
Sure. Yeah. No. And it just kind of depends, like, again, on the amount of money. But I'd say the big picture is no matter whether it's $1 or $100,000, the money is the settlement for the kid and the minor, and the parent or the guardian, whoever's in charge, is not allowed to use that money to provide stuff for the minor that parents are supposed to provide in terms of food, shelter, clothing, those basic things. As a parent, you're required to provide that, and you can't use the kid's settlement money to buy do the stuff that you're supposed to do as a parent, right? And the way that the system is, again, it's based on the amount, to where if the net settlement, so after attorney's fees and medical bills, after everything's been paid out, the amount of money that's actually going to the kid, if that is $15,000 or less, then the parent can just be in charge of it, and there's the court and nobody's looking over their shoulder, right? It's kind of honor system. Like, you're not supposed to use this to go take a vacation for yourself or to do stuff, for the kid that you're required to do. You're really supposed to put it in a bank account somewhere and save it until the kid turns 18 and give it to them, right?
Sure. And I think the thought process behind that is, with the amount of $15,000, the hoops that you would have to jump through and the amount of time that it would take and the attorneys that would have to get involved to make those determinations on how to spend that money would almost be counterproductive in terms of the amount of money that's going to the kid, because you would almost end up spending all of that $15,000 trying to achieve the goal of protecting it and where it's going to go.
Right.
So I think, the legislature's made the determination that that's kind of the cutoff. Like, we're going to give you authority to do what you want to do with that amount of money, but anything more than that, then, we need to start having a discussion about what you're going to do with it and put more safeguards in place as to how the money is going to be used and when it's going to be used.
Exactly, yeah. If the amount of the settlement, that's the net settlement after paying out everything that's going to the kid, is $15,000 or more, that's when basically the law says you have to have a guardianship put in place, which is basically where the court appoints someone to be in charge of this money and make sure it doesn't get wasted or spent inappropriately. Most of the time, I'm thinking back through the cases I've handled. I mean, usually it's whoever is in charge of the kid ends up being the guardian most of the time, not always, but whether it's the parent, the mom and dad, or grandparents, or whoever. But there's then basically reporting requirements that come with it, right? I mean, I've seen it two different ways. One where, like, mom and dad are appointed as guardian, they're allowed to keep the money in whatever bank account they want to keep it in, but then every year they basically have to file documents with the court, like annual reportings, basically showing, here's how much money we spent of the kid's money this year, and here's the reasons why. And then the judge is supposed to review it, and technically if the judge reviews it and decides that wasn't appropriate expenditure, the judge could order them to put the money back. Right. I think that's the most typical way, but I've also seen maybe a little bit more extreme in terms of safeguards, where the judge will just order all the money to be put into I can't remember the term, basically like a locked bank account, to where in order to withdraw even $1 from the bank account, you got to get the judge's pre-approval. So you got to go to the judge on the front end and tell him, I need to spend this much money, here's the reason, and get approval from the judge before you can even go to the bank and take the money out.
Right. And then the way I like to do it, and the way you can make it very easy on the attorney ad litem, the guardian ad litem, the judge, everybody, is to put the money in what's called an annuity, a structured settlement. And basically what you do is you bring in this third party, say the kid's 5 years old and he's getting a large amount, he's getting 6 figures of money, or, even 7 figures of money. What you're doing in a situation like that is you're placing the money into an annuity that, it can't be touched until, and you can set these things up. There's a million different ways that you can set these things up. You can set it up where, the minor's not getting, they're getting a certain amount of money every year until they're 40. You can set it up where they're getting all of the money when they turn 18. You can, put some of it in a college plan and put some of it into an annuity and put some of it into a brokerage account. There's a million different ways that you can do it, but at the end of the day, basically what it's doing is it's putting the money in, it's investing the money. And so that way, when the kid turns 18 or the kid turns 21, there's going to be a lot more money in that account than what there would be if you just put it into a checking account and we're spending it on, different things that they need until they turn 18. So
Exactly.
and I have yet to see a situation where a judge has not approved a settlement in a situation where I put it into an annuity, because at that point, it's in the best interest of the child 99.999% of the time to do it that way.
Yeah, exactly. Because like you're saying, it's earning interest. It's locked up somewhere safe. It's insured, and it's earning interest, and it's out of everybody's hands. So there's no way that someone could just go decide to take a trip to Hawaii or something like that, because that's all locked. The money's all locked up, right?
Right. Exactly.
Because I know we've never had this happen in any of our cases before. But I mean, the flip side of this is, if a parent were to squander the kid's money, go spend it on the parent, spend it on him or herself. Technically, once that kid turns 18, the kid could turn around and try to sue the parent to get the money back, right? I've never actually seen that. I've never been involved in anything like that, but I know it's technically possible, right?
Yeah.
Where the kid could have a claim against the parent. And so again, you're like, by locking it up in an annuity or a structured settlement, you're just taking that off the table, right? There's no way that's going to happen.
Right. And, not only that, the attorney can actually get in hot water too. If the kid turns 18 and the kid then comes back and says, well, you just gave the money to my mom, or you gave the money to my dad, and it was an amount of money where you shouldn't have done that. And we can get in hot water as well. And speaking of moms and dads too, one of the things we didn't touch on is who gets to make the decision. And I know you've been in situations before where, the parents, there's a lot of divorce in our society. And, the kids are splitting time between the mom and the dad, and they don't necessarily see eye to eye on the way things should be done with the child. And there's situations where the mom might actually go out and hire us as their attorney, and the dad might go out and hire a different attorney as the attorney for the child. And then those two different attorneys have to come together, and they have to make decisions together and come to compromises between what the dad wants and what the mom wants for the child. And I know you've been in that situation before, and it can prolong the case, and it can create a lot of frustration and a lot of headaches. In my opinion, it's always better to be a united front and have one attorney. And I know you probably feel the same way, just based on some of the things you've had to deal with in the past. Yeah. But it is certainly within the rights of the parents to get separate attorneys for the child.
Yeah, no, it is. And like you said, I've had it come up several times, and it can get messy. Like you said too. Normally in those situations, I'm approaching it from like like talking to the two parents, like in a situation where they're divorced, they maybe don't have the best relationship. And it's like, look, whatever issues you still got between each other, like put that aside and let's focus on being united for the benefit, like focus on the kid, right? Like put your crap aside, focus on the kid, so we can try to all be on the same page. But it's easier said than done. And like you said, I've had a couple different cases where it was just like a bitter divorce. Like the parents really hated each other. And, in one of the recent cases, the dad hired me, the mom had hired a different attorney, and it was almost like two battles. It was like, me and the other attorney, we were on a united front in terms of like battling against the defendant and the insurance company and getting the biggest settlement we possibly could. That was the best thing for the kid. But then aside from that battle, then there's also a battle between the mom and the dad, and where me and the attorney are basically trying to, mediate the situation and get mom and dad on the same page, and again, try to, because what a lot of times ends up happening is whatever issues that led to the divorce start popping up here, and now we're not even talking about the kid and the injuries and everything. We're talking about, oh, you're a jerk, you cheated on me, I don't want to, whatever you think we should do, I'm not going to do, just because out of spite,
just
basically.
that stubbornness and that spitefulness comes out in this case, and it shouldn't, but it does.
Yeah, it's something you got to deal with sometimes, and again, just try to, the way I've always handled it is just trying to remind everybody, like, let's put that stuff aside and focus on the kid. You know what I mean? Like, hopefully you can, if you guys can agree on one thing, it's that you both love your kid and you want the best thing to happen for your kid.
Right. And I think most of the time what happens is at the forefront, they're like, yeah, we can do that. That's great. But then, they don't foresee some of these little issues that pop up, and, they're making lots of decisions and trying to get two people that aren't necessarily friendly with one another to come to an agreement on, 100 different issues. There's going to be probably half of those issues that they're not going to agree on.
Right, absolutely. And honestly, I mean, it's one other way it can get a little complicated or dicey, so to speak, is really just between the two attorneys in that situation. Because, when you're talking about, and just when it, to be blunt, when it comes to money and attorney's fees, right?
Yeah.
Because, I mean, there's just, there's two parents that each have their own attorney. There's only one injured minor, and so there's only one settlement that we're getting for the kid. And, the way we work on a contingency fee, it's not a situation where both attorneys get to take a percentage of the kid's money. I mean, it's just one attorney fee that gets paid, and then you can end up in a situation where the two attorneys are then having to try to fight over, how they should get a portion between the attorneys.
I did more work. I did this, I did that. And then the other attorney's like, well, I did more work on the front end and you did more litigation work. And I took the deposition of this key witness. And, I did this if it's in trial, I did this at trial. And, everybody thinks, each attorney's making their pitch as to why they did more work and why they deserve more of the fee. And you're right, that can turn into a whole separate issue that can prolong the case and create more headaches for everybody.
Absolutely. No, exactly. I mean, luckily, I think with the case, I know the cases I've handled, I think you too, it's, we're always basically able to come to an agreement with the other attorney up front and usually just agree to, split it. Like I'm representing one of the parents, you're representing the other parent, so we'll split the fee. And so we haven't had to get in any of those messy hearings over attorney's fees, but it definitely happens. You hear about it, and I will say that if there's one thing that certainly juries and to some extent judges are not sympathetic about, it's greedy lawyers fighting over money.
That is
nobody
true.
cares.
That is true. Nobody cares about the argument between the attorney about who's getting more money from the fee on the case. Right. Like, nobody's going to be sympathetic, and nobody's going to want to take the time to make the decisions on that. So it's always better to mediate those situations beforehand and come to a decision on that stuff before you have to get before a judge, because you're not finding any sympathy.
Yeah, no, that's right.
No matter your injury, Nonni Homola is here to help you recover. Visit noho.law today.